Okay, good morning. Today's interaction will be for the young lawyers, recollection of studies about jurisprudence, for aspiring candidates who are approaching for examination of judicial officers. It is fundamental basic discussion. For social reformers, political advocates, active politicians, this is for common civil code. The question arises, unless and until you understand what is law, that is jurisprudence, and how laws developed, what compels the sovereignty or constitution or any authority to codify the law, amend the law, whatever it may be. Before that, you must all kindly understand the imperative school, positivism. That means it commands legislation, judicial precedent, customary law. They say ubi civitas ebit lex. That means there should be always state sovereignty and administration of justice. Then exportorial jurisprudence. What the law ought to be, all these things are not necessary. The concept of law of Austin and Kelsen are vary each other. They say legal norms itself is an order of human behavior. So we must only concentrate for time being, because today topic would be uniform civil code. Then as I earlier said, the law is of legislation, judicial precedent, customary law. See, custom should not be against the public policy or imposed on the citizens, like sati, child marriage, these things, denial of property rights to women, all these are imposed on the citizens by sovereignty or whatever it may be. Therefore, everybody accuses Sanadana Dharmam. See, that is not pertaining to caste disparity. You can accuse Sanadana Dharmam whenever that Sanadana Dharmam encouraged sati, encouraged child marriage, and specifically encouraged the denial of property rights to women. You know, for your kind information, before 1956 Hindu Marriage Act, the Hindus can marry many wives, no prohibition. Only after 1956 monogamy was introduced and polygamy was banned. See, this is what you should all understand, how law. See, what is natural law, what is moral law, what is divine law, what is law of God, is also correlated to uniform civil code. See, we have Vedas, the Vedas having been translated, then Upanishads, Prabandhagas, Smritis are there, and slowly it reaches the modern pen and the computer systems to write whatever they want to write about Vedas. If anybody writes something which is voluminous, if somebody says at one particular place in Pacific Ocean water is sweetie, We cannot go and search where that water is available for our sweet tongue. This is where everybody writes, everybody speaks. The great, claiming to be great scholar, simply accuse why a uniform civil code or not. But what? Because it is at the stage of discussion, and I want to discuss about that. These customs which is against the public policy are being banned, like sati, child marriage, and the denial of property rights to the woman. But where is social engineering process? Where is social transformation process for claiming this? See, that is what earlier what happened. Ecclesiastical system of jurisprudence is being followed. Sovereignty was controlled by religious heads. Even in India, where multi-number of kings, samasthanas, rajas were ruling at their various levels, all are controlled by their religious gurus. The saints are being given much important. Even if saint commands a king to send his sons to fight or to protect his yajna, other things, king cannot refuse it. This is the way where Europeans were controlled by Pope and Christian priests and heads. Likewise, all over India, all over the world, multi-number of religion being followed, and that impact was on the ruling sovereignties. But so far, the Muslim law is concerned, that law is particularly commences from Arab, and it slowly spread to Turk. That time, everywhere there was fighting, invasion, unruly behavior, vandalism. Therefore, whenever these Islamic brothers meet each other, they used to say, Assalamu alaikum. Assalamu alaikum will be a peace. But after that, they will start fighting. Whatever it may be, that social prevailing circumstances were codified as controllable norms of law, positive law. Whether that law should be tested along with Hindu laws, which were totally guidelined and misguided by the subsequent authors and jurists of Vedas. Still, the legislation prevented certain menace and also brought several control over these Vedas imposed laws. And particularly sati was abolished, and child marriage was restrained, and women properties were given to him with 100%. To that context, and there are certain disparity in Christian law, Parsi law, and Muslim law, that men is entitled for double the share of women. That inequality should be eradicated. For all that purpose, and a multi-number of judgments intervened with Muslim personal law as well as Christian personal law by striking out the conformity of degree of divorce by full bench, that means consisting 3 judges, and paying maintenance during Iddat period was set aside, and the Muslim wives are protected for maintenance under 125 CRPC. So many drastic, that has to be codified. After all, this uniform civil code should be codified to the extent that let there be a conscious objections or resistance or their demand and their grievances should be reconciled before bringing uniform civil code. But you can bring uniform civil code regulating the procedures, leaving the area of personal, existing, customary law imposed by God. I hope you understand. So this is the subject I want to share with you today, and thereafter tomorrow I will discuss about the jurist for the exam purpose. I hope you understand. Best wishes.